Let's talk a little bit about what Social Security disability is, because I don't do those cases. I know it is its own unique area of the law, but what exactly are we talking about when someone talks about Social Security disability?
That's a great question. Most people think when they hear Social Security, they think of retirement.
Right.
They know that they have to pay a certain part of their paycheck every week or every other week.
And we're hoping it's around.
For their retirement. But what they don't realize is that they are also paying a disability insurance premium, because Social Security has a disability insurance program, or a program that runs like a disability insurance policy.
Something that will protect you if you can't work. And we'll talk about the details of that, but essentially sickness or injury and you're unable to get out and earn.
That's exactly right. And so as long as you have worked long enough paying into the system, if you become disabled according to Social Security's definition, which we'll talk about, then you can be eligible to collect disability benefits through the Social Security disability program.
What are some of the basic elements then that someone would need to show to the Social Security Administration in order to be entitled to a disability benefit?
The first thing that you need to understand is Social Security's definition of disabled. Social Security says you're disabled if you can't engage in what they call substantial gainful activity, and I'll explain that in a second, and that the condition is either going to result in death or will last or is likely to last for at least 12 consecutive months.
So they're looking, first of all, at something that's really serious.
Correct. The first thing that people need to understand is the meaning of substantial gainful activity. And Social Security defines that in terms of a dollar amount.
Probably a lot of legalese too.
A lot of legalese. But the bottom line on it is that if you are unable to work doing any kind of job at all, full-time, 8 hours a day, 5 days a week, then you can qualify as disabled.
That would seem to me to be a very high burden, actually. It means you can't be the greeter at Walmart or sitting as a guard.
That's exactly right. A typical job that they will ask about at a hearing is, can you take tickets in a movie theater?
Okay.
Can you sort mail in an office? Can you sit as a security monitor?
Can you sit as an outbound caller trying to sell people timeshares?
Absolutely. And what Social Security does not consider is what you did before, what income you generated from that, versus what you might make taking tickets in a movie theater.
So you could be a high-end executive, make $250,000 a year, but as long as you're able to take tickets in a movie theater, you wouldn't be eligible for this type of disability benefit.
That's correct. I've represented medical doctors, and we had to prove that the doctor was not capable of even taking tickets in a movie theater in order to be found disabled.
We'll talk in a little while, because a lot of people have private or group disability policies, and that's different. So again, that's a really high burden. How do you go about helping a claimant prove that burden?
One of the keys in these cases is medical evidence, but it's not just the evidence to show what your diagnosis is.
Sure.
Your diagnosis is just the starting point.
It's just a label, actually.
It's just a label. And what Social Security wants to know, of course, is what's wrong with you? What is your diagnosis? And I'm not just limiting it to one condition. For most people, they have a combination of conditions that are limiting them in their ability to work. So the medical evidence needs to show what's wrong with you, but more importantly, it needs to show what are the symptoms that you have from your condition, and in what way does that limit you?
How does that
affect
or limit you?
Exactly.
Right. From being the ticket taker at the movie theater.
That's exactly right. An example I give people a lot is the example of diabetics. Mm-hmm. There's hundreds of thousands of diabetics in this country, most of whom are fully capable of working at some job. There's a small percentage that have complications, and one of the complications is a condition known as neuropathy. And people who have diabetes recognize that. They'll know what that is. Sure. But it's a complication that causes for some people, severe pain in the feet or the hands, numbness and tingling. It affects your ability to walk. It affects your ability to hold objects. And so for those people, those are the kinds of limitations that are likely to affect your ability to work and prevent you from being able to do any kind of work. But we have to have the evidence that shows that you have this complication, what treatment's been tried, how it's affected you, and what limitations you still have once you've gone through a treatment regimen.
In a Social Security disability claim, what types of evidence are we talking about? Are we just talking about medical records? Do doctors come in and testify? Do friends come in and testify? How does that work?
The way it works is medical evidence is part of the evidence, but it's not the only part of the evidence. Medical doctors generally don't come in to testify unless they've been called in by the judge as a medical expert. And most treating doctors are not going to have the time to come in for a hearing. But what we do for our clients is we will contact their treating doctors, and depending on what's wrong with them, we'll send the doctor a specific type of questionnaire or disability form asking for the doctor's opinions about specific limitations that I know are important in trying to prove somebody can't work.
There's all these Social Security disability regulations that you as a lawyer know about, and again, now my words, you're trying to fit it into some sort of a matrix. Because as you say, a lot of these folks, they'll have a dreadful disease, but they have a lot of things going on. So they may have a cognitive loss, they may not be able to feel, they may not be able to stand or walk for long periods of time. And part of your job is kind of put that all together to show to the administration the whole person, right?
That's exactly right. That's exactly right. And so we can do it through these reports from the doctors. Sometimes through the course of a case, Social Security will actually arrange for a client to be examined by a doctor in the community who has agreed to do examinations and reports for the Social Security Administration.
Let me ask you a question about that, because in my world, in the personal injury world, of course, the insurance company can send people for a so-called independent medical exam, and we kind of know who's on that list, and we kind of know what they're going to say before they say it. Is it that way in Social Security?
Yes.
Oh, wow.
There are some examiner, they call them examiners, doctors or psychologists if it's a psychological issue. There are some that do a really excellent job, very thorough, and really give a fair report. In my experience, it's not the majority. Many of the reports that we get, they're not positive, they're not negative. To be honest, they really don't tell you much of anything at all. But if Social Security orders it, then you need to go through with it, because otherwise you'll get a denial based on non-cooperation. And it will come to the judge's attention that you failed to show for these scheduled appointments. Yes. There are certain cases where I will ask a family member or a close friend to come to the hearing to testify if the client particularly has cognitive issues that I do a lot of work with brain injured clients, and they may have a really difficult time in describing what their limitations are. And so I will bring in friends or family members to do that. But that's not typical. And the reason why is that these hearings are really laser focused. They may only last 30 minutes to an hour. And you have to get to the point very quickly. And most claimants, which is what Social Security calls them, most of my clients are good at being able to describe what their limitations are. Now, I work very hard with them in preparing them for the hearing to do that, but they're able to do that, so we don't need additional witnesses to come in. And you had asked about whether there's a lawyer on the other side, and the answer, as I said, is no, because it's really not a good use of time and resources for the Social Security Administration. The judge needs to understand what the world is like from the client's point of view, what their day-to-day world is like, how limited they are, what areas of personal care or household care they need help with, to paint a picture for the judge of what their life is like, and then understand through the medical evidence what the medical limitations are, so that the judge can make a fair decision.